Thank you so much for attending. The panel we will have this afternoon is Challenges to International Criminal Law, Post-2025, Rethinking, Reframing, and Reforming. So hopefully you're all in the right room and you weren't hoping to attend the panel on international human rights law. This afternoon, we're all in for a treat with some very interesting presentations covering different aspects of international criminal law. We'll have discussions about universal jurisdiction, immunities from prosecution, and negotiated justice, and consider how international criminal law can evolve to meet the challenges of a multipolar world. My name is Émilie Pottle, and I'm a barrister at Temple Garden Chambers. We were expecting this afternoon to hear from Dr. Aloka Wanigasurya, but he's unwell and isn't able to join us. So we won't be hearing from him this afternoon. We do have some participants joining us online, as well as all of you here in the room. You're all very welcome. We'll begin by hearing from Miss Danielle Flanagan. She is an associate at Hogan Lovells, LLP, and her presentation is Rethinking Universal Jurisdiction, a Shift Towards Greater Universality.
Good afternoon, everyone. As Émilie stated, my name is Danielle Flanagan, and I'm an associate at Hogan Lovells in New York in their international disputes and litigation practice. And in my presentation today, as Émilie also mentioned, I'm hoping to explore how we can begin rethinking universal jurisdiction, particularly with respect to how this principle may be trending towards greater universality, which I'll touch upon by what I mean in just a moment. As I was saying, and as a bit of background, universal jurisdiction is a principle which can be generally summarized as the legal authority of a state over certain international crimes, regardless of a territorial or national nexus, to the alleged act or actors concerned. And this principle remains subject to considerable contention due to its very far from universal application. And to appreciate that very contention, 166 of 193 UN member states, for instance, have incorporated universal jurisdiction over one or more international crimes within their domestic legislative frameworks. However, I would say that's considerable, although the invocation of the principle has generally remained limited to states in the global north. So with this jurisdictional form and how it serves as an important complementary mechanism to ensure that perpetrators do not enjoy immunity, where a territorial state is unable or unwilling to exercise its legal authority, its selective invocation has only reinforced certain asymmetries. And take, for instance, just the disproportionate investigation and prosecution of actors from the global south and its attendant encroachment on state sovereignty. So with this backdrop in mind, I would just say that this evolving application of universal jurisdiction by states in the global south represents a noteworthy shift in this very dynamic. Recent invocations of the principle include that of Ghana for crimes committed in the Gambia by its former head of state, Argentina for crimes committed in Spain during its civil war, and Senegal for crimes committed in Chad by its former head of state. And these three exemplary invocations illustrate the potential for states to reverse traditional patterns of legal accountability. And this presentation therefore seeks to offer a critical analysis on the normative underpinnings of universal jurisdiction and how this jurisdictional form may in fact be made more universal. And in doing so, I'm hoping to explore two overarching universal jurisdictional frameworks that have emerged in this post-1945 period. And second, we'll profile the above three case studies that I mentioned and how they have reimagined universal jurisdiction as an those two overarching frameworks. I want to say that before considering the far from its very far from universal definition. arrest warrant case, there is no generally accepted definition of universal jurisdiction under either customary or conventional international law. And in fact, none of the judges in that very arrest warrant case explicitly posit a definition of universal jurisdiction, despite the incorporated interpretations as to its scope. So for purposes of just streamlining that discussion here today, I'm only going to really look at this jurisdictional form and how it may be reduced to two overarching frameworks, that being the absolute universal jurisdiction and conditional universal jurisdiction. Under the framework of absolute, which has also been referred to as universal jurisdiction in absentia, states may investigate or prosecute the accused for certain international crimes, irrespective of a territorial, national, or other nexus to those crimes. So this framework, in effect, is based solely on the nature of the crime. And in other words, the accused need not be present nor retain any link to the forum state. So as archetypal examples of this form of jurisdiction, historically has been Belgium and Spain. And under their respective criminal laws, investigations and prosecutions were permitted regardless of either the defendant's presence in the forum state or the nationality of either the defendant or the victim. But other states have instead trended towards what's been called conditional universal jurisdiction, and this requires a link between the accused and the forum. And under this framework, states may investigate or prosecute the accused only where certain conditions attach, and those conditions do vary state by state. And while they may differ, the act of conditioning the exercise of this principle has really gained currency among states, including Austria, Bosnia, Canada, Colombia, India, the Philippines, the United States, among others. And this conditioning may in part be due to of evidence, among many other concerns as well. But as this retreat from absolute to conditional universal jurisdiction appears to continue, it really does remain to be seen whether such retreat coincides with its more frequent and universal invocation. And that's really the focus of my presentation here today. So moving to those three case studies that I mentioned, and turning to the application of the principle, prior to 2009, complaints invoking universal jurisdiction were predominantly filed in the Global North, as I mentioned before, with a few notable exceptions. But in the years to follow, states in the Global South have increasingly undertaken universal jurisdiction cases, and they've reached various case stages as well, ranging from the filing of initial complaints to the completion of trial. And considering this trend, the presentation seeks to examine three different cases that have reached various stages of the case life cycle: Argentina, where there were formal proceedings; Ghana, an investigation; and Senegal, a prosecution which culminated in a trial. And reviewing these cases, I also endeavored to identify simultaneously potential explanatory factors application. And among the number of potential explanatory factors, which I understand are many, and I can explore all of them in this presentation today, part as to when and how and at what frequency this principle is being invoked. So moving first to the case of Argentina, universal jurisdiction in this state context derives from Article 118 of the Constitution, which I have here on the screen. You can see the relevant language. Essentially, and as you can see, when the crime is committed outside the borders of the nation against the law of nations, Congress may determine by special statute the place where the trial is to be held. And Law 48 also just supplements that very provision and states that courts and judges in the exercise of their functions shall proceed by applying the principles of the law of nations. So these provisions taken together truly do establish a solid basis for the principles exercise in Argentina, although don't provide any indication as to its scope, as to whether conditions attach. And if we look at a prominent case in profile, that being a case that was filed against former Spanish authorities during the Franco era in Spain. You can see notably, it was not only on behalf of Spanish victims and survivors, but also Argentine descendants of those same or national link. And here Argentina is conditioning its exercise of universal jurisdiction on the nationality of the victims. And if we move now to Ghana, it, I would argue, likewise conditions its exercise of universal jurisdiction, despite there not being express language in its domestic legislation. Here, there is a catch-all provision, Section 56 of the Court Act, that has been argued to serve as a, so to speak, basis for the invocation of universal jurisdiction. But again, if you read the text on the screen, it doesn't articulate whether or not conditions attach or if it can be exercised under the absolute framework. And the scope of this provision has not been tested by Ghanaian courts, but legal practitioners have observed that the Ghanaian judiciary is conservative by nature and that the courts are unlikely to exercise jurisdiction purely on this catch-all provision, which appears to suggest an addition from the one case in profile we have here today, and that is against the Gambian President Yahya Jammeh for the massacre of an estimated 50 migrants in the Gambia, and notably 44 of whom were Ghanaian nationals. So in other words, you have this clear national link to Ghana for it to exercise jurisdiction. So in view of these observations, I would argue that Ghana here appears to be trending towards a framework of conditional universal jurisdiction. And finally, to consider Senegal, the principle of universal jurisdiction here derives from Act number 2007-05, and this amends the Senegalese Code of Criminal Procedure. And here the Act specifically and expressly includes conditions for certain enumerated crimes for the alleged offender and whether or not they're arrested in Senegal, if the victim resides in Senegalese territory, or if the government secures the alleged offender's extradition in some way. So unlike the other two contexts, it's very clear that there are conditions required for the exercise of universal jurisdiction. But even in addition to this express language, the case against former Chadian President Hissène Habré, which culminated in his successful prosecution, demonstrated their attachment of conditions as well. And they brought charges against Habré once he was residing in Dakar, and that therefore is the territorial link for Senegal to exercise jurisdiction. So although only a small these three case studies only represent a small cross-section of the various universal jurisdiction cases out there, I would say that this pattern of conditioning universal jurisdiction, particularly among states in the Global South, is considerable. And as we briefly previewed, this unchecked exercise of universal jurisdiction or absolute jurisdiction leads to conflicts between states, can subject defendants to due process and other procedural abuses, and potentially prompt politically motivated prosecutions, among other things. Each of these possible outcomes, I argue, arise from this unconditioned application of universal jurisdiction and how it may carry the potential to trigger a retaliatory response against the invoking state. So considering the various state positionalities in the global legal order, states in the Global South may be a bit more inclined to adopt a tempered version of universal jurisdiction for reasons that are both strategic and practical. And I've outlined those reasons here on the screen. First, just simply requiring some jurisdictional link, be it national or territorial, avoids the perception of judicial overreach. It also avoids the risk of forum shopping, both of which may be viewed by other states as an encroachment on their sovereignty, especially when the forum state opines on certain matters that are of domestic concern. And diplomatic tensions may then flow from such cases, and forum states may wish to avoid raising that political specter. especially if it's politically inconvenient for a state to have such a wide jurisdiction. And second, on a simply practical level, requiring the presence of victims or the alleged offender, for instance, in your territory, just helps streamline a criminal case. You have access to evidence, witnesses, the offender and parties themselves, and that's particularly attractive to states with less investigative or prosecutorial capacities. And simply put, it increases the feasibility to conduct a fair and efficient criminal case. And to look at the case, and specifically the trial of Hissène Habré, it was estimated to cost around 8.6 million euros just for the trial. So these cases are incredibly expensive. And I think not all states have the same capacities to entertain cases, especially if it doesn't touch on their nationals or that state has any particular tie to the case at hand. And third, these links, national and territorial links, curtail the volume of universal jurisdiction cases. Otherwise, it really would create significant pressure for the case docket, and there may not be the sustainable use of judicial resources. So simply by conditioning its exercise, you limit those number of cases coming through the door. And courts can instead be reactive than proactive. And some states with limited judicial capacity may have an interest to take that position. So all of these reasons underlying the conditioning of this framework, I think, is key for why states generally, and those in the Global South specifically, have increasingly invoked this jurisdictional device, and that being conditional universal jurisdiction. Thank you, and happy to answer questions.
Thank you very much for that, Danielle. It's very interesting. Next, we're going to hear from Professor Atahindi from the Murphy Institute. He's a visiting assistant professor of law, and that's at Tulane University School of Law. His presentation is Here Comes Your Ghost Again, Individual Immunities for International Crimes.
All right, well, thank you, everybody. It's an absolute pleasure to be here for the first time. The title of my paper is Here Comes Your Ghost Again. For those of you who are familiar with good music, it's homage to Joan Baez's Diamonds and Rust. And well, I'll be damned, here comes your ghost again. It's basically a reflection of my concerns regarding international rules, applications, and interpretation within the scope of individual immunities for international crimes. The reason I thought about this title was because in many ways, and from my humble perspective, I think that a lot of the debate concerning concerning immunities for international crimes really reflects international law's colonial and imperial origins, or something of the past, through its legacies, or something of the present. They represent normatively and figuratively have greater privileges than others. While there is certainly a shift, I think, in the international legal order that we can be cognizant of, the present is not so far removed from the past. What do I mean by that? Well, it's an aspect that I'm currently exploring through critical legal scholarship, especially TWIL, but before I go into all that, some context I think is due. I was pushed really into thinking about these topics based on my personal and professional career. They were issues that, due to my proximity, both as a professional and within my personal life as well. My readings of attempts to exercise universal jurisdiction over certain individuals, including Israeli individuals, and the subsequent reactions from those specific states and others, were especially upsetting. This was of particular personal and professional interest as a Palestinian, I am myself, and as a scholar who loves all things Palestine and international law. Maybe not all things international law. I can't stand trade and investment stuff, but some people like it. I'm not good at it. So one of the things I like to consider the designation of the special mission status on Zippy Livni some years back when she visited the UK, something that the UK didn't even have to do. It's not like she was going to be arrested. For those of you who are familiar, I'm happy to talk about that a little bit more. But I was also fascinated with the divergences between the International Criminal Court and the African Union on the discussion as it related to the former Sudanese President Omar al-Bashir, who was wanted for the crime of crimes, right? The crime of genocide. As a justice and accountability advocate, of course, my inclinations were in support of the ICC project. During that time, though, while I was working on the situation in Darfur, I thought to myself, okay, but what if, right? What if Netanyahu or Bush or Obama? There were clearly some discussions that raised allegations and concerns of double standards and hypocrisy, but nothing specific, right? I couldn't really get to the rules. I didn't have something to work with. But I noticed that the same actors that were actively lobbying against the court's involvement in Palestine were supporting the court's involvement in Darfur, Sudan. For example, the UK. The UK, we knew behind the scenes, was actively lobbying. Am I allowed to talk about this here? Is it like the US right now? No, I think I'll be okay, right? You kick me out, send me back to the US, and then they'll send me back here. But anyways, the UK was actively lobbying the ICC prosecutor behind the scenes from the intelligence that we had as civil society to have them working against the Palestine's 12-3 declaration under the Rome Statute, right? And then came the ICC arrest warrant said against Putin, right? There's something to work with now. It seemed relatively clear, but for the switch in here, not including a UN Security Council referral. So from a positivistic point of view, the argument there is that we don't have a Security Council referral that is mandating and forcing cooperation upon states because there's no referral. This is different. This is coming from the court. Then came the arrest warrants against Israeli Benjamin Netanyahu and former Minister of Defense Yoav Gallant. Yes, now we finally have a measurable standard. Indeed, we saw statements on immunities in the most abstract and vaguest terms imaginable, seemingly collecting bits and pieces of different rules together to what was highly expected, that they will not arrest either of them if it came to it. It's important to note that bar some extraordinary situation of some state, for example, Hungary, frankly not giving a damn, practice demonstrates it is more likely that states won't invite such a scenario. Just don't come here so that we won't have to, you won't put us in a situation where we have to explain why we won't arrest you. Right? There exists a wide array of what we call immunities. Between the two different categories of immunities, which I'll speak about in a second. And it was reported at the time that, Netanyahu's plane while flying over Europe avoided certain states, right? Netherlands, Ireland, Iceland, while others were not avoided. They were flown over, Croatia, Italy, and France, right? For the most part, the idea of immunities is generally tied to the sovereignty of the state, is that the state itself that decides who can and cannot be investigated and prosecuted for the alleged commission of international crimes. In many ways, this makes sense. How can state A engage with state B if the former's court is going after the latter's officials? You're ruining all types of relationships between both states. So here we're going to ignore our lip service, of course, worship to the so-called principle of independence of the judiciary. We just don't like it when it concerns judicial decisions in the global South Third World. Here, it doesn't matter, right? Essentially, what we want to do is we want the smooth and successful conduct of international relations. After all, international law provides the rules that guides peace and war from prosperity to death and destruction. For the most part, we know two sets of immunities. First, personal immunities. General, this is limited to three types of titles: heads of state, heads of government, ministers of foreign affairs. Many of you are familiar with this. It's limited to the individual's duration in office. As such, we can catch those guys later after they're done. Of course, in some states, they last forever, right? They can be heads of state forever. Second, then there's functional immunities. This could work for anyone attached to individuals performing an act of the state. And these attach forever, right? Like love. This has typically been seen as not working for international crimes. Then there's this whole mess of like everything else, at least as far as immunities are concerned, or lack thereof. Some examples include the relevant provisions of the Rome Statute of the ICC, or specific treaties pertaining to the diplomatic and consular relations, as well as so-called special missions. It's a little warm in here. One addition is the language of operative paragraph 6, right? It's this specific paragraph included within UN Security Council's Resolution 1593 of 2005, referring to the situation in Darfur, as well as UN Security Council Resolution 1970 of 2011, referring to the situation in Libya. Both of those resolutions included language referring those specific situations or those respective situations to the ICC. But they also included within both of those what we call operative paragraph 6, which basically allow for immunities of individuals coming from states who are not states parties to the Rome Statute. How do we treat those? How do we deal with those specific provisions? How has the court or anyone else treated them? Well, we've simply ignored them. What are some possible scenarios? The paragraph is severable from the remainder of the resolution if we were to treat it like we treat treaties based on, for example, paragraph, I believe it was 96 of the Kosovo Advisory Opinion or their interpretation thereof. Or we just cancel the whole resolution. We just get rid of it, throw it out, right? But we don't really have we don't really have much practice with that. And I don't think that makes sense. I think that would be a little bit too extreme. But most importantly, at least as it concerns that one, I think the takeaway is one international organization cannot bind another international organization unless the latter international organization allows for the former to do so, such as in the case of referring the situation to the ICC, but not in creating immunities. So how do we solve these various dilemmas? We have all these different sets of immunities under international law, most of them derived from custom, and then there's these treaty-based immunities, but we don't know how to deal with them. There's no kind of set standard. Generally, I would like to consider a rule of law-based approach, one that is black letter, doctrinal, and positivist. Of course, this assumes that we all agree on what's black letter, doctrinal, and positivist. My approach, I think, is quite original. I coin it the practice what you preach approach. Personal immunities have very limited exceptions, and those exceptions are those based in name and title. So you think about the ICJ arrest warrants case, the time and the name check out, hence immunities. Belgium rules with respect to that particular case, Belgium rules on universal jurisdiction before and later, and then changes its laws when it's pressured by the US because of the suits possibly filed against George Bush and Ariel Sharon. And then we have function immunities that are drawn from state immunities and not some sort of catch-all phrase. They pertain to sovereign acts, and do not include international crimes. Most recently, we have the case of Ziada versus the Netherlands, where the Dutch courts concluded that 2 Israeli officials were basically protected from civil proceedings in the Netherlands due to function immunities. This immunity arises from the fact that their actions were taken in their official capacity as part of Israeli government policy, essentially canceling out everything we know about investigation and prosecutions of violations of international humanitarian law, particularly grave breaches, which create obligations. Essentially, these attacks resulting in the deaths of 6 members of Ismail Ziada's family in Gaza Strip in 2014 were quote unquote official acts protected by functional immunity. How much time do I have left?
6 minutes.
Okay, perfect. They're already all bored of me, but I'll try to spice it up in the last 6 minutes. This position that I know immunities this position that there are no immunities for international crimes has been a topic of consideration by the International Law Commission. Some of you may be familiar with this topic. For them, at least in its latest iterations, is straightforward. There are no immunities for a series of international crimes. When it concerns functional immunities, these include genocide, crimes against humanity, war crimes, crime of apartheid, torture, and forced disappearance. It raises a lot of questions with me. What about other inhumane acts like gender apartheid or ecocide or some variation thereof? All these new crimes that are coming out. Or collective punishment, serious violation, not a grave breach. Grave breaches and other serious violations. There's a sliding scale, obviously, in terms of what we include. Why are apartheid, torture, and forced disappearance specifically mentioned? Aren't they already crimes against humanity? Or aren't some of them war crimes like torture, which can be either or? Of course, this has not been met without criticism. For me, one of the standouts is Sean D. Murphy's piece, who was at George Washington Law School, was serving as a member of the ILC. And he has some arguments. He says it's not lex lata. He says the lack of state practice, let alone widespread, representative, and consistent state practice is just not there as it concerns this exception for functional immunities. There are enough cases, he says. There's not enough statements at the ILC to support this view. Clearly, there's a divide. Joanna Pacheco explains 11 states, Brazil, France, Iran, Israel, Japan, Russia, Saudi Arabia, Singapore, UAE, United Kingdom, United States, were overall critical to the rule contained in that draft article. 4 states, Malaysia, Morocco, Germany, and the Republic of Korea, presented neutral or ambiguous positions. So clearly there's a divide. And to be honest with you, that's not great company. I wouldn't want to be in that company anyways. Sorry to anyone from those countries. International relations would not be such a justification in support of this contention, and others like sovereignty, I think, are unconvincing. I find this approach to looking at state practice unconvincing. How many courts? How many states? Which states? Did certain international crimes require such an assessment as a prerequisite for investigations and prosecutions? Is this not at all the purpose of the ILC's work, the progressive development and codification of international law? I want to take it a step further. At the very least, there is clearly some recognition on the name and title and duration as it concerns personal immunities. The other ones just seem to be very confusing. But if our end goal is ending impunity and our objectives are justice and accountability for international crimes, then we may consider that as far as certain categories of international crimes are concerned, there are no immunities. Here I'm thinking about the intent to commit a crime and knowing that these rules will, or at least may, protect you. In line with this, of course, it's necessary to engage in a more technical exercise of ascertaining which rules fall under these categories. Genocide is perhaps straightforward, but there are other crimes against humanity and war crimes. Which crimes? Which elements? So, for example, the fact that no international court ever pronounced on the crime of apartheid in South Africa doesn't mean there was no crime of apartheid in South Africa. Similarly, we look at consider the Gaza Strip and the possibility that the ICJ and ICC may never really look at the issue of genocide. Doesn't mean a genocide didn't occur in the Gaza Strip. Further, with respect to the notion of not enough state practice, the lack thereof may be due to the fact that there maybe is just a lack of international crimes, which should only be met with alhamdulillah, or thank God. Perhaps it's due to the states just being unwilling as opposed to, unable to do so. Then, of course, not thank God, not alhamdulillah. I think that personally, we would be much more content if we were intellectually honest. We accept that the rules apply for some and not for others. And the reason for this is based on power or second coming, or as was mentioned earlier, which I thought was a fascinating way of looking at this, not international law, but the rules-based international order, as the state sees it. On that note, full circle, we might see how this from a global South Third World perspective. If colonial imperialism is our point of departure and that the origins of these rules or the powers that create and maintain them are to be addressed, how do we address them? Drawing from RP Anand, what I've always been fascinated with, perhaps there are rules we can accept, some we can reject, and some we may just have to adapt. Obviously, it's not a dichotomy that's drawn by a perfect line. Let me be clear about that. At the very least, the rules, application, interpretation of international law pertaining to immunities can no longer be conducted to what I think is best termed as a standard of convenience, one that works for one part of the world and not for the other. On a final note, with respect to the ability to conduct international relations, that's understood. But this certainly raises questions. One, is there only one person in a state that's able to be a minister of foreign affairs or a head of state or head of government? Certainly, we now have a Secretary of State in the US who deports persons on the flimsiest basis, while his predecessor oversaw the deaths of 15,000 children. There surely must be somebody more qualified to conduct international relations in some of these states. I think we're past that argument. It's outdated. It may also, number two, but it also may, I'd like to recognize that it may paradoxically reinforce the same concerns I raised here. Who makes a determination? Who decides on who or who cannot conduct international relations on behalf of state? I haven't and won't figure that out. Keep your expectations low with the final outcome of this paper. So every time it would seem that we have moved into international law focused on justice and accountability, and the fight against impunity, I say, here comes your ghost again. In order to make that ghost go away for good, we need a standard. Perhaps that might be a standard where there are no exceptions. But if there are any exceptions, that may be clear, they may be quite limited. Thank you.
Thank you very much for that, Professor Émilie. Next, we will hear from Dr. Giovanni Chiarini, who's an assistant professor of law at Alfaisal University. His presentation is Negotiated Justice Transformation from World War II Military Tribunals Ethical Denial to Modern International Courts Procedural.
Thank you very much for the moderation, to all of my colleagues for the speech before, to all the attendees. My topic is a bit more procedural, so usually when we talk about procedure, it's a bit more boring, but it's a part of the international criminal justice, one essential part, especially when it comes to the practical life and living life of international criminal law. That's why I say negotiated justice transformation. What I try to explain is that negotiated justice evolved from the military tribunal, Nuremberg at Tokyo, where there was a very strong ethical component. Nowadays, in the present days with ICC, there is more a procedural view, far from being ethical, in my opinion. And the practical life of the ICC, as I will explain, is one of these examples. Of course, just very shortly, I don't want to take everything for granted. Maybe there's some undergraduate students who are not familiar. Negotiated justice in the presentation means two things, essentially: guilty plea and plea bargaining. Guilty plea, what does it mean, procedurally speaking? You're omitting the charges against you, not guilty, you're denying. And plea bargaining is the arrangement between the prosecutor and the defense that follows the guilty plea. Okay, so where the defense counsel and the prosecutor are trying to bargain a sentence and get a lower sentence in exchange of something that might be a guilty plea on some charges, or dropping some charges in favor of another, or different qualification of charge. If you look at the origin of international criminal justice, which is the trial of the Kaiser, even if it's a failed trial, it's still relevant for, I think, at least the theoretical life of international criminal law. And the first attempt, even the trial of the Kaiser, was never established, as you know, and the tribunal was never constituted. Article 227 of the Treaty of Versailles in 1919 said, if you read it, the associated powers were trying to try the Kaiser for supreme offense against international morality and the sanctity of the treaties. They talk about person guilty of criminal acts. So what emerged from the Treaty of Versailles? I just mentioned some sentences. Have already been considered guilty. That's why they didn't even mention the possibility of guilty plea. Then, as we know, the Kaiser fled to the Netherlands, to the Hague, actually, what is today is surprising the House of International Criminal Justice. He found asylum, the trial was never carried out, but this is how negotiated justice was considered zero, essentially, in the trial of the Kaiser, because international criminal justice, as we know, has a strong component of victor's justice. This is what characterized also, if we look at the picture in the 1919, with the Victor Power playing European football with the Kaiser. So this is the defendant that was accused of crime, and this is something that characterized international criminal justice, at least in the not ancient times, because 1919 is even 100 years ago. The situation changed with Nuremberg, although there is still a strong ethical component. If you look at the statement by Robert Jackson, the American chief prosecutor, this is a beautiful speech, but it's still very, very heavy and ethical. You see, he talks about the darkest and most sinister forces in society, dictatorship and oppression, which is, I agree with this, but it's not something that should belong into a trial. I'm more technical procedural view, but there's a lot of rhetoric in Nuremberg, which again is totally understandable for that time. But as you see, this trial represents mankind's desperate effort to apply the discipline of the law. So in such a framework, in such an environment, of course, it would have been impossible to allow the possibility of a plea bargaining to negotiate a sentence. How can you negotiate a sentence if the prosecutors say this at the beginning of the trial? It will be inconsistent. That's why if you look at the law, Nuremberg Statute, Article 24 allows only the possibility to plead guilty or not guilty without any opportunity to negotiate the sentence. That's why no defendant plead guilty, because if you plead guilty, potentially you can get to the death penalty. There's no any benefit. And another interesting trait of the Nuremberg Tribunal is that the mention of the guilty plea, which is Article 24, paragraph B, is included not in the rights of the accused, but in the power of the tribunal. So I think the interpretation, in my opinion, of the Nuremberg Statute speak loud about considering the guilty plea something that relates more to the trial itself, not to the choice of the accused. If you look at the record of the trial, the defendant in this case was Göring, which was far from being a sin, but still an accused on trials, was even stopped at the phase where he was allowed to plead guilty or not guilty. He tried to make a statement before I answered the question of the tribunal whether or not I'm guilty. He was stopped by the president. Then he said, "You're not entitled to make any statement, just plead guilty or not guilty." And if we have to find a trait of evolution of negotiated justice, we can find it, even if it's a very small step, in the Tokyo trial. In the Tokyo trial, Article 15 and 13 essentially mirror the Nuremberg Statute. But at least the defendant is allowed to make spontaneous statement when he's called to be declared guilty or not guilty. So there is still a little bit more of rights of the accused, or at least to make spontaneous statement during this. The situation radically changed with the United Nations Ad hoc Tribunal. Honestly, regarding the Nuremberg trial, it's already overexplored. And that's why it was justified, as I mentioned before. Nuremberg was not only a trial, but also the mission to establish a precedent, okay, to be a deterrent, to serve as a historical record. That's why allowing a plea bargaining would have hindered this process and not even allowed it. So this was the historical reason behind. As I say, the situation changed with the UN Ad hoc Tribunals in the 90s, now International Residual Mechanism, but ICTY, ICTR, for former Yugoslavia and Rwanda, where the bargaining is including in the statute, even very short proceeding, and it evolves due to the case law of the tribunal and of the judges. But even here, it's very interesting, in my perspective, comparative procedure, essentially, to see how the idea of applying plea bargaining changes depending on who is the president of the tribunal who is analyzing this issue. If you look at Antonio Cassese, he's Italian, like me, who was the first president of the ICTY. In Italy, as other parts of Europe in the civil law tradition, the plea bargaining is allowed, but there is a precise limit of sentence. You can plea bargain, but up to 5 years of imprisonment. Again, for mass murder, for example. So Antonio Cassese said we have to be very careful in allowing plea bargaining and negotiated justice when we talk about international crimes, because international crime is the gravest possible of all crimes. That's why during his presidency, as a civil law, European lawyer, there was not a lot of cases of plea bargaining, not 4 or 5. When the presidency changes, and the president was Judge McDonald, who was an American. So in the US, they massively use plea bargaining, especially she was from Texas. So in Texas, they have a 95% of proceedings solved through plea bargaining. They started to use plea bargaining massively, and 30 defendants decided to use plea bargaining. So it's interesting to see, in my perspective, how the legal culture that you belong into as a practitioner will influence the practical application of international criminal law in theory and in practice. Another interesting point in the guilty plea and plea bargaining in the jurisprudence of the ICTY and the ICTR is that the judges decided to set some minimum preconditions that you can find actually in a dissenting opinion of Judge McDonald and Vora, which were based essentially on the standard of European Court of Human Rights and other jurisdictions. But they say that the guilty plea has been made voluntarily, informed, not equivocal, and there is sufficient factual basis. So the guilty plea and the plea bargaining negotiated justice proceeding evolves through the jurisprudence in the 90s. So from being totally denied to having been developed through the jurisprudence. What does it mean? We don't have time to analyze all the requirements, which is not even a requirement, a minimum precondition. So if even one of these lack, there can be negotiated justice. Voluntarily, the judges of the ICTY, in a specific case, they said the accused must be mentally fit to understand the consequence of pleading guilty, should not be affected by any threat or promises, even from the defense counsel. The guilty plea is informed, so you really have to understand the nature of the charge against him and the possibility of classification of criminal conduct either as a crime against humanity or as a war crime. There is a case where the defendant pled guilty as a crime against humanity, sentenced 10 years, and then he realized with another defense counsel that this crime with the same facts can be classified as war crime, and he gets a deduction of the sentence to 5 years. Because in the ICTY, ICTR, you can also make an appeal in the negotiated justice. So this is another important step. Very shortly, the guilty plea is not equivocal. Essentially, the factual basis should not contradict the basis of the indictment, and there must be sufficient factual basis to support the indictment agreed with the prosecutor and with the defense. Purely procedurally speaking, there are 3 negotiated justice proceedings in the ICTY and the ICTR. The ordinary one that we just mentioned, another one which is a special procedure in case of amendment of the indictment, and another one again that there is one case in the ICTY where is a special negotiated justice in case of contempt of the tribunal. There is one case in the ICTY where a witness decided not to answer the judges, he got indicted, and then he entered a special proceeding. But they are minor, they are not very relevant, honestly. But just to say that there are 3 plea bargaining procedures in the ICTY, we went from 0 to 3. The situation changed again with the Rome Statute of the International Criminal Court in 1998, which then is operative from 2002, where the guilty plea and plea bargaining, which was inspired somehow, at least for the minimum precondition, from the ICTY and the ICTR, but it was totally reconstructed and reformulated in 1994, between 1994 and 1996, in a discussion between 2 different representatives, one from common law and one from civil law tradition, where they decided to, they say, bridge the gap between common law and civil law system, because the procedure, I don't want to go into that, but the procedure of plea bargaining between common law and civil law is radically different. Especially, there is a lot of limitation in some European jurisdiction, as I said before. And the discussion was between the Canadian representative and the Argentinian. So the Canadian coming from a common law jurisdiction, if we exclude Quebec, which is a French-oriented, and Argentina, which is a Roman law-oriented European tradition. They decided, especially from Argentina, the Argentinian was very critical about the possibility of introducing a plea bargaining for all the crimes and this escape for the trial. So they proposed to find a compromise between a common law of the Canadian plea bargaining, where you can plea bargain without any limit of sentence, and the Argentinian system. In the Argentinian system, the plea bargaining essentially lead to an abbreviated proceeding. That's why Article 65 is not called plea bargaining procedure, it's called abbreviated proceeding on an admission of guilt. We look at Article 65 of the Rome Statute. So essentially in the International Criminal Court, the accused of crime has the right to plead guilty, and when the defense counsel and the prosecutor reach an agreement on a range of sentence, so they propose not a specific sentence, but a range of sentence, for example, from 9 to 11 years, so they can go to the judges and ask the judges to activate an abbreviated proceeding, but there is still a trial. It's a mini trial, it's a very short trial, but there is still a trial. So there is still a record, and there is still some weaknesses. We have one case only. Here is Article 65, but so I don't want to read it. It's very procedural. Essentially, it mentions again the ICTY and the ICTR minimum requirements. In the only case, and I'm going to conclude in 3 minutes, of the ICC related to negotiated justice, which is the Almadi case, Almadi agreed, the defense counsel of Almadi agreed with the prosecutor a sentence between 9 and 11 years, which was a bit shameful because there's a list of long war crimes, which is very actually important, is a destruction of a mausoleum, a religious building of Timbuktu, between 9 and 11 years. The judges decided to accept the plea and to hold a trial of 3 days trial, 24, 25, and 26 of August, where Almadi is questioned, so the defendant is questioned, and 3 witnesses are cross-examined. Of course, this was not all the evidence from the prosecutor. The prosecutor would probably have called 30 witnesses in ordinary trial, but at least they celebrate this mini trial of 3 days to ensure that there was an historical record, and at least most important witnesses was heard at the International Criminal Court. Then Almadi got a reduction of the sentence recently from the appeal chamber due to the good conduct in prison, and it was reduced to 7 years. So, in my opinion, I think we should think about what the International Criminal Court really want to allow, procedurally speaking, because I agree with the idea of excluding any ethical concern from the procedure, which I think is, in a liberal view, it's a good interpretation of international criminal law, but at the same time, having 7 years of sentence for, I think, 5 or 6 war crimes, it's probably too low. I mean, you can get this sentence for a bank robbery, probably, in some way. But we will see how the negotiated justice procedure will evolve in the next years if any defendant will agree to enter another plea. And to conclude, the Office of the Prosecutor recently, some years ago, published some guidelines for agreement regarding admission of guilt, which in my opinion, they highlight, again, the importance of considering international criminal law in a more technical and procedural way than in an ethical one, because they set 8 criteria, and I'm not going to explain any of them because we don't have time. I will explain the article. And if you look at criteria 7 and 8, the prosecutor said, and I'm reading his word, that an admission of guilt is of particular importance because will eliminate or reduce the need for victims and witnesses to testify at trial, which can be traumatic, and I agree. But if we look at the efficiency, which is the last criteria in the guideline, the OTP of the International Criminal Court, the Office of the Prosecutor, expressly said that admission of guilt saves significant resources such as time, money, personnel, and court space. So I think the OTP is essentially admitting that there's not enough resources in the ICC. They have to save even money, because I think the budget of the ICC, 150 million. In an international court is not a lot. And he said those resources can be used for trial and appeal to be devoted to other important investigation and prosecution and advance the cause of international justice. So he also mentioned that efficiency is one of the main factors to take in consideration when we talk about resources. So I think that we are coming, if you analyze the history of international criminal law, from a strong ethical denial of any negotiated justice to a very technical procedural way to interpret negotiated justice itself. And I think I concluded in 20. Thank you.